Hi, everybody, and welcome back to another week of Samfiru Tumarkin's question and answer session on Facebook and now YouTube. My name is Aliya Virani, and I am an associate in their Vancouver office, and I practice all things to do with the employment relationship. Samfiru Tumarkin is primarily an employment law firm, which means that we specialize in everything to do with employee rights, employer obligations, anything that you may have come up in the context of your working relationship. And so I'm going to be here for the next half hour, available to anybody who would like to ask me some questions and answer them. I will answer them in real time. I'll see your comments appear as you leave them, and I'll be able to give you some information and some, guide you towards some resources that you can use if you're looking for some help to solve your employment law issues. We've been very busy recently getting a lot of questions about particularly bullying and harassment. That has been very popular in the context of COVID. COVID, of course, has changed a lot of things that we became, things that we were formerly familiar with. It's really put a wrench in a lot of those processes to do with, safety and, a violence-free workplace, or how to determine what type of conduct constitutes, behavior that you could be terminated for just cause. So certainly during the time of COVID, employment rights have been very important to refresh and remind yourself about, employers and employees, because we've seen a lot of, issues come up in the employment relationship that have to do with those, that have to do with kind of the backdrop of the pandemic. So anybody who may be going through a situation like that, feel free to leave me a comment. I'd be happy to give you some help with that. I get a lot of questions on a day-to-day basis about primarily how to determine when you've been let go if your severance package is, if an employee's severance package is fair. And so if I don't have any comments, what I'm going to do is go into a discussion of some of the more popular severance myths that I hear when I go through my day-to-day work, speaking with people after they've been let go. Like I said, a big part of what I do is help determine whether people have been provided their entitlements or whether their employer is following their obligations. And so there's a lot of misinformation out there. And if, employment relationships have to do with nearly everyone. Everyone's, at some point in their life is probably going to be in a relationship where they're working for someone or they hire someone to work for them. And it's always important to kind of refresh your knowledge, or maybe check yourself to see if you may have one of these severance myths as part of what you're thinking applies, but in fact it does not. So I don't see any comments just yet. Again, don't be shy. Please feel free to, leave me your questions. This time is devoted to you, to everybody who, maybe can't get access to legal advice, or, has some pressing issues that they can't wait to get legal advice for because it's traditionally, takes a couple of days to set up. So please take advantage of the fact that I am here. I'm an employment lawyer. My name is Aliya Virani. I work in Samfiru Tumarkin's Vancouver office, for anybody who's just tuning in, and I'm happy to answer your employment law questions. Otherwise, I'm just going to jump into the first severance myth that I hear about, probably the most commonly cited piece of information that I hear from people who I speak to on the phone after they've been terminated. And that is, they want to know if what they've been offered is fair. And they'll tell me, well, I've heard a little bit about this. I've done some research online, and I understand that I'm supposed to get something like 1 to 2 weeks of severance for every year that I was working. And so maybe it would help to go into a background of, what severance is and when you would be given severance and how this would come up. So in BC and in most provinces, I'm just licensed to practice in BC. An employee can be let go for any reason if they're non-unionized, but, it doesn't have to be because of poor performance. It doesn't have to be because there's anything wrong with what they're doing. An employer can just choose to let them go, but when they let them go, they have to give them an appropriate or their fair severance amount. And their fair severance amount can be provided either in payment, or it can be provided with notice of their termination. So it can be working notice or it can be payment. Most often it's provided with most people are familiar with a severance payment. And so I'm going to be, just to keep in mind that it could be both. It could be working notice or it could be payment. I do see some questions now. I'm just seeing in the corner of my eye. One from Miha Do, which says, "Hi, will it be okay if I contact you personally?" That's perfectly fine. So anybody who may feel uncomfortable, they're watching this, and you really want to leave a comment, or you have something that you need help with, but you don't want to make it public for everyone to read and associate with your name, completely understandable. You can reach out to us at our website, which is www.stlawyers.ca. You'll find a contact us info box where you can leave a brief description of what you're going through. That info box isn't shared with the public. It's given straight to our intake team, and then we can contact you. You can leave your contact information, your name, your phone number, your email address, that type of thing. And then we'll contact you to set up a consultation where you can speak with one of our associates. You're happy to request one of us personally if you go through our website and you find that maybe one of our backgrounds is best suited to the type of issue that you're dealing with. Otherwise, you'll just be matched with the first available person in the province that you have your employment issue, because the law can differ slightly between province to province. So, for example, right now, the rules in BC are slightly different than Ontario, but for the most part, we all deal with the same type of issues, and it's just a matter of finding someone that's best suited to deal with your issue. So I also have a question from Dave, and Dave asks, if I'm a shift worker, how much can my employer change my shifts before it's a constructive dismissal? That's a very good question, Dave. So wondering what the threshold of when a constructive dismissal will be found that's usually the most important topic when you're making that type of claim. And what you should do is this: at the first sign of changes being made to your shifts, you should say something to your employer about that. You should have some sort of objection in writing, because you don't want to set this history of incremental changes that you could be seen to have accepted because you don't speak out at the time. How to determine whether those changes are significant enough. If it's not, say, I think I need to know what your normal shifts are and then what the changes are. But we do have a set of cases that kind of explain to us, or by virtue of looking at the cases in the past, we can determine what's going to be a significant enough change in cases that are similar to those cases that you may be in now. And so if we're talking about wages, there are cases that set out something as even as low as 10% or 15% difference or reduction in wages could constitute a constructive dismissal. It's going to be a little bit fact dependent. So I'd need to know kind of what are the circumstances of your employment now and what are the changes that are being made, because, in your situation, maybe you have factors that mean that one shift change is going to be more significant of a difference to you than somebody else who may be in that same situation. For example, taking one of your shifts away and moving it to the afternoon when you simply cannot work in the afternoon if it was a morning shift, and your employer knows this. That's going to be something that contextually is more important for your determination of whether it's constructive dismissal than someone else. But there is a threshold that we're trying to see if those circumstances have crossed, and that threshold is trying to figure out whether the employer shows intent not to be bound by the terms of your employment relationship. And so if you would like to get some more specific advice, it's just very difficult to answer a general question of how many shifts, because I need to know how many shifts you start with, what shifts are being changed, and then the circumstances of your employment now. If I know that, then I'm certainly able to tell you whether a constructive dismissal is likely to be found or not. But because a constructive dismissal has to do with whether changes are significant enough so that somebody observing from the outside would have the impression that your employer is not intending to be bound by the terms of your employment, it merits just a little bit of a deeper dive into what's going on before I can tell you definitively, this is a strong constructive dismissal case, or maybe there's some risk here. But generally speaking, if you want to protect that type of claim, a good idea for what you can do next would be this. Anytime your employer is making some change, whether it be incremental or any change that you don't like to your employment relationship that you have never had before, it's best to let them know in writing, not in a conversation, that you do not agree with the change, that you're happy to continue on in your old terms of employment, which are this. The change is going to be this. It's going to have this type of effect on your life, and this is, why you don't, think it's appropriate. You don't even have to go into that much detail. You can just say that you don't like the change and you've never agreed to it and you've never had it before. But you want to be clear that you want to continue on your old terms. And then you can protect your claim in that way. So it's not seen for you, it's not seen that you're agreeing to those small changes, which over time could become more significant. So that's the thing. Maybe now they're not significant enough for it to be, maybe there's some risk with it being found to be a constructive dismissal if small changes are being made now, but it may be that later those small changes add up to be a very significant change. And so constructive dismissal claims in particular are really those types that I would recommend seeking counsel for, both to protect your claim and both so you can recognize what's going on. And I don't know if you feel comfortable giving a little bit more information, but if you don't, completely understandable. Xander, this is kind of what the question was in the beginning, which from Mihado was is it okay if I contact you personally? And just to kind of, continue that, Dave, I think in this situation, if you give me a little bit more information and if you want to contact me personally, then that would be a good next step to get the proper advice that you need to determine what's going on and whether this constructive dismissal claim, how it should be protected, how you can protect yourself, and when to recognize when it's reaching kind of that threshold point where you can move forward. And if there's a finding that there's been a constructive dismissal, then you can simply let your employer know that it's clear that the old terms of your employment no longer exist. They don't intend to be bound by them, and you can effectively treat yourself as being terminated and walk away and still claim your severance. But there's some important things that you want to do to make sure that your claim's protected before that point. And that's why I want to, I'd really be interested to hear a little bit more about what's going on and give you some appropriate information so that you know what to do. So Xander, like I said, that was the only question from the beginning from Mihado, is just, if you want to, reach out personally to us, you're more than welcome to do that. I would be happy to go through in more detail and, review your documents, for example, if you want to collect those, and send them in to us when you ask or set up an appointment that sets aside some time for us to go through this together. It's definitely the best idea to get the most information reviewed so that you can get the most specific advice. So I have another comment from a viewer who asks, can my employer terminate my position when I am on long-term disability? So very good question. Kind of goes to some of the things that I get asked when people have been let go and they want to know, has my termination been carried out properly? If you're on long-term disability, I think it raises the question of, is your employer terminating you because of your disability? And if that's the case, then you could have human rights issues that have been raised by your termination. And your employer would have to show that your termination had nothing to do with the fact that you were, that you had what's known as that protected ground of illness or disability under the Human Rights Code, that had nothing to do with the reason that they're terminating you. Because remember, you can be terminated for any reason as long as you're not unionized in BC, but your employer has to provide you your fair severance. That being said, you can't be terminated for an improper reason, which would be anything to do with a status that you hold under the Human Rights Code, one of the protected grounds under the Human Rights Code. So that means you can't be terminated because of your race, because of your gender, because of your sexuality, because of your disability, for example. So if that is something that's going on, then you could bring what's called a human rights tribunal complaint against your employer, because that is it's a dismissal that is discriminatory, or it's against your rights under the code. So that's just something that I would kind of signpost about your situation that could be relevant to the type of claim that you want to bring, if that is something that you're interested in pursuing, or if that's something that you've been experiencing. If you'd like to reach out to us and get a little bit more information about how to bring that type of claim or what you could, recover, and certainly maybe to explain a little bit more about what's been going on, if there's things that have been said or done that are improper while you've been on long-term disability, then that would certainly be relevant and worthwhile investigating. So, and again, if you'd like to reach out to us, you can go to our website at www.stlawyers.ca. Otherwise, you can just, if you have any search engine, just Google or Bing or any other search engine, type in Samfiru Tumarkin and you'll get to our website. And then we have that contact us form where you can, like I said, fill out your details, a little bit of your background information that you are curious about and want to know about with respect to the types of, claims that you can bring. And then, leave us a way to get in contact with you, and then we can set you up with an appointment with one of our counsel. Okay. So I have a question now from Chris Blue, and Chris says, how long do you have to deal with a wrongful dismissal? That is a wonderful question. It's something that everybody should know, and just keep in mind anytime you have something that you think could potentially turn into an issue, just always remember these dates because it has to do with your limitation period. That's what it's called, is a limitation period for bringing a claim. And if you let these limitation periods pass, you could have an excellent claim, which entitles you to, the full extent of the remedies that you have under the law. It has nothing to do with the strength of your claim. But if you wait too long, then you'll be prevented from bringing that claim. So you don't want to wait until these limitation periods pass. And for a claim that has to do with your severance alone, that would be 2 years is your limitation period. So 2 years from the date that you were terminated. If it's just to do with maybe being provided an insufficient or not appropriate amount of severance, upon your dismissal. If it has to do with breaches of your rights under the Human Rights Code, then it's a little bit of a shorter limitation period, and you want to make sure that you keep this in mind. It's 1 year from the date of your termination or from the date that you were discriminated against in the context of your employment. So that could look like, maybe it could be you not being accommodated properly when you're returning to work after recovering from an illness or injury, or it could be potentially your employer, maybe there's a new manager or a new supervisor that you have, and they are starting to discriminate against you on the basis of your gender or sexuality or race. So it would be 1 year from the date that those types of discriminatory events or acts has started. And so it's much shorter than the regular limitation period that you have for bringing just a straightforward severance claim. And so you want to keep that in mind, that generally speaking, it benefits you to seek legal advice and to take action on your claims as soon as possible. But if it's been going on for a while now and you've kind of been curious about it and you don't know if you've run out of time, now would be, now if you haven't done it yesterday, the second best time is today. I'd really encourage you to take advantage of the fact that a lot of our consultations can be free. Only if it's kind of a more complex issue that requires a lot more of our time will we just charge, like a nominal fee that doesn't even represent probably most of the time that we're spending going through the materials. But, we want to make this information as accessible as possible. And we'd be happy to go through exactly what you need to do to bring a claim or to get protection for your rights, or how you can put yourself in the best position possible to remedy the situation that you've been placed in through no fault of your own, just by your employer perhaps not meeting their obligations to you, whether that has to do with a human rights issue or a severance issue, or just other terms of your employment that should be followed that have not been followed. So I have another question from Paul, and Paul asks, if an employer terminates you, can they immediately cease your group benefits plan? They can. So this is an interesting topic. I think it comes as a surprise to a lot of people that, first of all, there's no obligation for an employer to enroll their employees in or provide a health benefits plan. And certainly when they're terminated, there's no obligation to continue the health benefits plan. But what can often happen is when you're provided a severance package, or when a terminated employee is provided a severance package, as part of that severance package, there will be a continuation of benefits under the benefits plan. And that is something that a terminated employee is entitled to receive over their common law severance period, or just their full severance entitlement. So what that means is that when you've been let go and say you decide to renegotiate your severance package because you've been provided something that is below your legal entitlement, when you're seeking your full entitlement, you're seeking all aspects of your pay. And that includes any amounts that you're having to pay out of pocket because you're no longer on a benefits plan. That has to do with, or that also includes, say, like a car allowance or a cell phone allowance, anything like that you were compensated with, an annual bonus. When you're let go, that becomes part of your severance claim when you're asking for your complete and full severance entitlement. So they can discontinue it on your termination. Certainly it's within their rights to do that, but they need to ensure that they're providing you a fair amount of severance, and that severance that's provided to you is your complete severance entitlement, including any out-of-pocket expenses that you are now incurring because you are no longer under, the provision of their group benefits plan. Okay, so I have a comment from Tammy, and Tammy asks, how long does your employer have to give you your ROE? Wonderful question. So this gets asked to me a lot. Especially because in COVID times, we need a lot of employees need their ROEs to register or to enroll in EI. Employers are supposed to provide your ROE within 48 hours of dismissing you. So that's something that needs to be given to you fairly quickly. In reality, I see a lot of employers providing this much later than they're supposed to be. What you can do about it is this. You can still start the process of applying for EI. Typically the only thing you really need your ROE for is to apply for EI. That's one of the main utilities of this document. You should always confirm your termination in writing. That's another thing that you can do that can help protect any type of claim that you can bring, and it's just a generally good idea. But beyond that, say if you have something that says, you're terminated without cause, just a letter, and then they're taking some time to get the ROE, you can maybe email them and ask them to confirm that. But, you may find that you need your ROE to apply for EI. And if that's the case, you can get that process going. You can always contact Service Canada, let them know that you're still waiting for your ROE, but you've been terminated without cause. And, it's not like a with cause dismissal. And even if it is a with cause dismissal, then you may still be eligible for EI. So you can still get that application process going. Hopefully at some point they'll provide your ROE. Keep asking them for it if they're not. But like I said, the main utility of the ROE is to make sure that you are enrolled in EI if you're applying for EI. And there's other ways around that. You can, send in your application. You can contact Service Canada, let them know maybe there's an issue with receiving your ROE. Service Canada will contact your employer. They'll confirm that you've been terminated. At that point, your employer will probably release your ROE, or at the very least provide it to Service Canada, and then you can get that application going. But there's really no reason for them to delay providing that to you. That being said, it still happens. There's still ways around you doing what you need to do as if you had the ROE. And so that's practically speaking the best solution that I can give you, is just go through that application process, notify Service Canada that you are still waiting for this document. They can confirm independently with your employer that you've been terminated, or just at that point, that confirmation email could be helpful to them. And then, it's not as satisfying as if your employer just did the right thing from the beginning, but unfortunately, there's times where your employer is just not going to act according to their obligations, which is why, you can seek counsel if it gets to a point where you find that you need an advocate to support you through that process. This is why we are here, because unfortunately employers don't do things fairly or properly or according to their obligations all the time. But luckily there's a practical solution there. You do have options. Most of the times I do see the employer eventually providing the ROE within a couple of days. Maybe it's not 48 hours, but maybe it's a week or a week late. And so in that week time, you can still apply for EI, let them know that you have been terminated. They can, fact check that or otherwise confirm it with information that you provide, like a confirmation email of your termination. And there's ways around it in the meantime so that you're not affected negatively by their failure to be organized and provide the documents that you need. So I have a question from Chris, and Chris says, should I talk to you or labor relations about union fair representation? They haven't done anything. There's multiple people involved. That's a very good question. So I often am speaking to people who have issues with their union representative. Sometimes it's an ineffective union rep or relationship between the union and the employer, and not a lot is getting done when there's issues. You're going to be governed by a collective agreement. And so I answered this in a previous question, in a previous Facebook Live question and answer, because I understand it's very frustrating, but the situation is this: private counsel is not allowed to step in on behalf of unionized employees. And the reason is this: it is going to be governed by the labor board, labor relations board. You are going to have to go through a separate process. We would represent terminated employees in the civil courts, or say like the Supreme Court or the provincial court, and you're going to go to a tribunal that deals specifically with union issues. And if a private lawyer just tried to bring a union issue in our courts, then it will just be thrown out immediately. They wouldn't have, it wouldn't even be heard on the reasons that you're having issues. The court would say, you're not bringing this to the correct process. The union representative has to bring this on behalf of the unionized employees. And we don't have the powers to hear this. That court doesn't have the power or the authority to hear your issue. Private counsel are not allowed to sort of step into that role between the union and the unionized employee and the employer. It's sort of like it's just outside of our sphere of work that we can do. And so I can understand it's frustrating, and it's in most of the time, it's very desperate situations that unionized employees feel like they have to go outside of the union to seek help. So I can imagine that this is probably a pretty frustrating experience that you're going through if you're, looking for private counsel and you feel like your union rep, which is supposed to be devoted for this purpose specifically, is not doing their job. And I wish that I could. I wish that I could step in. And I know that a lot of my colleagues feel the same, but we're simply just not able to take union grievances to the civil courts. It would not be something that, no matter how much we wanted to do it, would be successful in having that issue being heard. It would just simply be sent back to your union representative and to the labor relations board. So I'm very sorry to hear that you're having issues. And I think the best advice I can give you is just to not give up in, getting the union representative to take those issues seriously, and maybe getting some more support from your colleagues, or not just, being persistent about that issue. Okay. And I have a follow-up comment from Tammy, and Tammy says, it's been 2 weeks and there's still nothing, and EI is waiting. So Tammy, you must be waiting, just for people who are maybe tuning in now, waiting for her ROE that hasn't been provided by her employer. So common situation, extremely frustrating, and can prevent you from receiving your EI benefits if EI is trying to confirm, whether you've been terminated without cause or with cause, or looking for the information about the statutory severance that you've been provided on your termination so they know when to start your EI benefits. The best piece of advice that I can give here is that you either have, if you have a confirmation of your termination and the amounts that you were provided on termination, say in a termination letter, that you can send that to EI, and otherwise let EI know to contact your employer and provide them with the contact information for your employer, and see if they're willing to contact them directly to let them know that, they're waiting for that ROE so that they can process your EI application. Otherwise, it never hurts. I think a lot of these situations, an employee will know that something's wrong. The employer is not doing something, but there's that gap of communication where it never hurts if you feel comfortable. And that's the other thing, is sometimes it can be very uncomfortable to do this, which is completely understandable. But if possible, if you could reach out to your employer and let them know that you're waiting, I'm sure you probably already have, but just to consistently remind them and let them know why it's important, that it's affecting your EI application and it's being held up. And basically it's causing you a lot of frustration, aggravation. It's a vulnerable time for a lot of Canadians, where EI benefits are extremely important. And so if you can emphasize the importance of why you need your ROE to your employer, then, if you decide to maybe have your severance package reviewed and it turns out that they haven't provided you all of the things that they were supposed to provide you, even beyond not giving you your ROE late, then that could be the type of thing also that can not necessarily support a larger claim, but just paint a picture of how you've been treated by your employer and why that may be inappropriate or why they may have fallen below the standards that they're supposed to follow overall. And gives you as much detail as possible if you ever decide that you are in a position where you want to bring a claim against them. So if they've done this improperly, maybe they've done other things improperly, and they haven't met their full severance obligation to you, and perhaps it wouldn't hurt to have a full review of what exactly else they've done when they let you go, to see if everything that they should be providing you has been provided. So Tammy, I think this it could potentially be the tip of the iceberg of what you're entitled to, that your employer hasn't been giving you. And if you'd like to have us review that for you, then I'd welcome you to contact us at www.stlawyers.ca, or otherwise, if you have access to a search engine, you can always find each of our associates has a profile on our website, and you can find our direct email addresses, and you can email us directly, essentially with a description of what's going on, and then we can forward that to our office and set you up with a consultation and go through this with you in a little bit more detail. Because chances are, if one thing is gone overlooked, then maybe there's a lot of other things that could be improved upon in terms of the way that you were let go. So that's all the time that we have for this week. I really appreciate everybody's comments. Thank you very much for joining me. Again, my name is Aliya Virani, and I do these Facebook Live sessions every other week. I look forward to seeing all of you, not next week, but the week after, and answering your employment law questions then. Thanks.